Joining us now with a lot more is NBC News Justice reporter Ryan Riley, and also with us Andrew Weissmann, former FBI general counsel and an MSNBC legal analyst. So, Ryan, what do we know about the injunction? And you would have thought it would be an automatic appeal of this. This seems like a very big deal. If the White House can't talk, it's not an order, but talk to social media companies about content when there are erroneous, COVID information, misinformation going on the air, and interference in elections.
Yeah, it's very important for there to be some sort of communication, but it's also important for those things to be sort of regulated in some way. We shouldn't have the government suppressing speech. I think in the examples a lot of the examples that we've seen thus far come out of this sort of litigation, and some of the discussions about this have been discussions about whether or not content violated Twitter's existing rules. That essentially it was government officials flagging things that violated Twitter's or, for example's ongoing policies. So I think while we have to be very cognizant of the First Amendment considerations here, I also think you have to look at the evidence of what those communications actually were. And I think it's important to remember that, this Trump-appointed judge made this, I think purposely chose to make this declaration on July 4th. And that his order, in fact, says, if true, this would be one of the biggest violations of the First Amendment, which is a pretty big, caveat, I think, to his entire sort of, 155-page, entry there. So I think that that's sort of the context that we need to consider, where who this judge is, where it's coming from, what date it was chosen on, and what the facts actually are, as opposed to what is alleged in this initial lawsuit.
That's why I'm so surprised that it's taking the Justice Department this long, or the Solicitor General, so this long to even respond, or the White House counsel. So, Andrew, what does it mean for users' experience online, the kind of misinformation they could encounter? You could argue that the pandemic, in some instances, and election interference is a national security issue.
Absolutely. So the judge tried to deal with that, but I think in a, frankly, a way that's just not palatable for the Department of Justice and, frankly, for the safety of this country. The judge said, you can have communications about national security matters. However, you can't have communications that in any way would induce a tech company to do anything. Well, that's inconsistent. The whole reason you would be flagging things of national security, I remember, just to give you a concrete example, learning of information that was online that revealed the location of military leaders in a foreign country. And we alerted the general counsel of a tech company because we didn't know if they knew about this being on their platform. They thanked us very much, and they made their independent decision about what to do. That would be banned by this order. That is why, Andrew, to your point, it is inconceivable to me that this will not be appealed. One, because it is legally wrong, and two, because the harm to our national security and, frankly, to just domestic crimes that are brought to the attention of tech companies is so severe. So it's just very hard to imagine that this won't be appealed.